Okay. Ms. Jones, you're the court reporter for today?
Yes, I am. Can you hear me?
Yeah, you're pretty quiet, but we can hear you. More importantly, can you hear us?
Yes, very well.
Fantastic. If at any point you can't, let us know and we'll see what we can do from this end, okay?
Okay, thank you.
Before we get on the record, there are 3 people in the waiting room. We've started setting up waiting rooms again. We had a hearing recently that people got on who shouldn't have been on and it got disruptive, et cetera. So there's a Kurt Cooper, a Jesse Fleming, and a Madeline Bader. Should any of them be let in yet? Should they be let in one at a time because they're testifying?
So Madeline Bader is me.
Oh, okay.
I thought maybe it might be easier to share with my witness my screen so that I can have my documents readily available.
So Madeline Bader's being admitted.
Okay.
The best way to share exhibits is through you being on the Zoom session and then sharing your screen.
Okay.
If you are trying to share something with a remote witness and you're not sharing your screen, you're holding it up to the camera, and that has never worked well.
Yes.
How about Kurt Cooper?
Kurt Cooper is my witness that will be testifying.
Okay, and Jesse Fleming?
Jesse Fleming is another potential witness.
Okay.
But he's actually on the board of the homeowners
Great.
association.
Well, they are in the waiting room, and we'll leave them there until you are ready for one or the other. Then let's get on the.
And I mute. Okay.
Yep, you muted. Excellent. Let's get on the record. This is case 2020, old case CV343257. It is Briargate Townhome Association versus Mohammed Habbassi and Naima Jabal. If I could have the appearance for Briargate.
Yes, Your Honor. My name is Madeline Bader. I am the attorney for Briargate Townhome Subdivision. Do you want me to go ahead and get started or just give you?
Just wanted you to introduce yourself for Ms. Jones.
That is me.
All right, and representing Mr. Habbassi and Ms. Jabal.
Yes, good morning, Your Honor. William L. Colvin, PC, William L. Colvin. On behalf of the defendants, and to my left is Mohammed Habbassi.
Hello, Mr. Habbassi. How you doing?
Good, how are you?
I'm well. Thanks for being here. So we have a bench trial, and I just want to set what I think the stage is, and then Ms. Bader, I'll let you take over since you've got the burden here. What remains in the case are plaintiff's claims against defendants. There were some counterclaims. They've been dismissed. The complaint was amended in February of this year. As best I could tell, it was just to update the numbers because, as I mentioned, this is an old case and it's taken too long to get where we are. But it didn't bring new allegations or anything like that. It's simply with the passage of time, the unpaid assessments have grown, late fees, et cetera. But it remains a case in which Briargate is seeking to foreclose on its lien that is predicated on these allegations of unpaid homeowners association or townhome association fees, et cetera. Today is the day that Briargate will attempt to prove its allegations by a preponderance of the evidence. So I'll hear from Ms. Bader and any witnesses she calls. Mr. Colvin will be defending the case and will be trying to convince me that the Townhome Association has not proven by a preponderance that his clients owe these amounts or really any amount over zero, because then there'd still be a lien in place, and that Briargate shouldn't be entitled to the relief it seeks. So with that, Ms. Bader, you can, if there's an opening you want to give, that's fine. I've read the complaint. You can structure this however you want. But before we do that, Mr. Colvin has stood up. Sir.
Yes, Your Honor. I am trying to get on to the Zoom anticipation of the witness presentation. I'm just taking me a little bit longer to do that. I'm not sure I got the link either.
Okay.
For that, but I'm about to get on my iPhone with the internet connection. So I just need the link.
Well, I can get you the meeting ID number or the passcode or whatever it is you need.
Yes, Sean. All right, I'm on the internet, so let me Open Zoom.
Here's this, that helps.
Okay. Thank you.
Yep.
You just shared the access information,
The rule NISI, Your Honor, I believe had the meeting number and the passcode.
passcode. Great. Then I
And honestly, Your Honor, I just hadn't thought that far ahead to.
don't worry about it. Just get online.
Sure, yes, sir. Yes, sir. Good time to tell. All right, it may be updated, Your Honor, but I believe let me hear. Close.
I'll know. You'll be in the waiting room and then I'm going to let you in.
So I had to reset my password. All right, I think that. Let me try my other. I don't know, Your Honor. I don't want to delay starting at this point. I don't think I have to have it.
Okay. Well, you can keep working on it and we will see what we can do.
All right, thank you, Your Honor.
All right. Ms. Bader, when you're ready.
Yes, Your Honor. I will give just a brief rendition of the kind of my opening, just a couple sentences so that I can set the stage.
Sure.
As we all know, Plaintiff is a homeowners association. As a homeowners association and pursuant to the declaration, they're entitled to levy assessments upon all of the owners in the community. And the declaration states that if a homeowner does not pay their assessments, there is a very specific procedure that the association can follow to try to recoup those assessments. This particular homeowner, Mr. Habbassi, and Ms. Naima Jabal, they live in the Briargate Townhome subdivision at 2230 Kilmington Square. And again, as we mentioned, the declaration does provide for the recovery of principal, interest, late fees, costs, and reasonable attorney's fees actually incurred. Today, we're prepared to offer the testimony of the association's property manager that will set out the amounts that the defendants owe for their assessments. That property manager is Kirk Cooper. And then just so that we're clear, the amounts that we're seeking today in principal totaling $6,420, late fees in the amount of $594.50, interest in the amount of $827.50, attorney's fees, including time for preparation and this trial today. And just a quick reminder, we were on a bench trial calendar before and have had a number of hearings on this matter and even tried to engage in settlement, drafted an agreement, and that was not, we can talk about that in a moment. But so the attorney's fees are $5,958 through today's trial. Court costs and expenses of $437.07. Now, there were some payments posted to this account, which we can get into with testimony, but we've reduced the total that would have added, that would have created by $2,175. We subtracted that for a total plus post-judgment interest accruing at the legal rate. We're seeking $12,062.07 today. I do, if I could, want to go ahead and enter, to be very formal, the declaration and the warranty deed, which start on page 2 of 130 of the exhibits that we submitted.
All right, let me get into those. Hold on one second. Yeah, so your exhibit is just one giant
It is-
PDF.
it is,
Okay,
Your Honor.
but I can roll with that.
I'm showing the screen right now. So exhibit 1 is the special warranty deed.
Okay, so that's at page 2.
Correct.
Okay,
Page 2 of 130. And then exhibit 2 is the security deed, which is here.
okay,
And then exhibit 3 is the declaration. Which, shame on me for not setting down the number,
it's the-
but it's page 72 of 130.
so one was the security deed or the warranty deed?
1 is the special warranty deed, Your Honor, on page 2 of 130.
Huh?
Exhibit 2 is the security deed on page 4 of 130, Your Honor.
Okay,
And exhibit 3 is the declaration, which is on page 72 of 130,
Yep.
Your Honor.
got it.
And because all of those are reported in, they're publicly filed documents in Roberts versus Roberts, which is 201 Georgia 357, the court can take record notice of those documents.
All right, any objection, Mr. Colvin, to the admission of plaintiffs 1 through 3?
No objection, Your Honor.
They're admitted.
Thank you, Your Honor. At this time, I would like to call my first witness, which is Mr. Kurt Cooper.
All right.
And I'm sorry, Your Honor, I thought I was going to get a chance to give a brief update.
You certainly can. Why don't we do, I wasn't sure if you were going to do that after Ms. Bader was done, but I'm happy to hear from you, and then we'll get Mr. Cooper in here.
Yes.
And hold on one second. You are actually in the waiting room. I'm going to let you in out of the waiting room.
All right.
So you're now in.
All right, thank you.
You bet.
Okay, too much of it. Briefly, Your Honor, my clients are defending this vigorously. I've wanted to state to the court that I think this is the third time I've appeared before the court. I don't know if the court recalls the other two times, but I do appreciate the court's considerations and the court staff considerations, because if the court recalls last November, I was extremely sick and unable to participate. So this matter was delayed in part because of my personal illness. So I just wanted to thank the court for that. Your Honor, I think that the plaintiff's case is problematic, and the evidence in the law is going to show that the plaintiff doesn't have the right to do what they're trying to do, because their declaration and bylaws are deficient in regard to not having the fines included therein. And I've got a case, and I just want to go ahead and cite to that, which is Abdullah versus Winslow at Eagles Landing Homeowners Association. And that's a February 2019 case at 823 Southeast 2nd, 872, 349, Georgia Appeals 615. And then also, it is going to be our contention that the plaintiff, pursuant to the statute that allows the impositions of fines and the conduct of this matter, is at 43-3-223. And I think that the plaintiff's locking my client out of the portal, where my client, the evidence is going to show that my client has continued paid payments from 3/19 or 3/1/19 to 3/1/20. He paid those timely, but the plaintiffs didn't account for those or credit those to the account in a proper time. So this statute doesn't allow them, I believe, to take the draconian extreme measure of locking him out. So that'll be a part of what we're arguing, or going to be arguing with the court, or presenting with our evidence.
Okay. Before you sit down, the first thing you said was that you don't think the plaintiff has the right to do the things it's trying to do. And I'm wondering, which of those things? Is it collect on unpaid principal? Is it to have late charges? Is it to seek interest on unpaid principal? Is it a term? Which are the things?
I think it rises from the imposition of fines and the characterization of those as assessments. The Abdullah case, which ironically was decided 8 days before the first letter went out, in this case on 3/1/19, states that if the fines aren't specified specifically in either the fine amounts for the alleged violation aren't specified specifically within the declaration or the bylaws, that they can't be collected.
Okay. You've used the word fine now a bunch of times. Is that what you're labeling the late charges? Because I don't know that, and I'm going to let you argue it when it's your turn, but just to manage expectations, I don't know that it's a fine if the declaration says, and I'm making the numbers up, if you live in this homeowners association, you have to pay $100 a month for your homeowners association fees. Different F word, fees. If you don't pay those, my understanding of every declaration and case law and statutory law is eventually the homeowners association can come after you to collect those unpaid fees. Now, they may also fine you for unpaid fees.
Right.
And that may be what Abdullah talks about, but you've used the word fine. And so I want to keep us on point. Are you challenging some portion of the 12,000 because it constitutes fines? Or by fines, are you saying, hey, my clients don't have to pay anything, they never did, and they never will?
I'm definitely not saying they didn't have to pay anything, but when the 3-1 letter clearly states that he was a fine of $25 a day would be imposed.
Okay, well, we'll get to that. That's fine. The evidence will be what it is. I just want to make sure we don't spend too much time talking past each other. If what Briargate is seeking to collect is unpaid fees, it may well be that there is a layer in there that constitutes fines, and there may be an issue with the fines. We'll get to that at the appropriate time. Thank you for sharing what you shared. All right, Ms. Bader, if you want to call your first witness.
Yes, Your Honor.
That Mr. Cooper?
It is. The plaintiff calls Mr. Kurt Cooper.
All right, he is entering. And if you, do you want on the screen what you've got on the screen?
Yes, Your Honor.
All right.
That's page 61 of 130.
Mr. Cooper, if you could unmute, please.
I am unmuting.
Your Honor, actually, do you want me to take this off the screen to be more? Can you stop sharing for just a moment?
Yeah, why don't you, so we can see
Yes.
Mr. Cooper more clearly.
You have me now?
I do see you, and I want to do that. All right,
Perfect.
excellent. So Deputy Gordon's going to swear you in.
Can you raise your right hand? Do you swear or affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you?
I do.
Lower your hand, state and spell your name for the record.
William Kurt Cooper, WILLIAM. Kurt, KURT, Cooper, COOPER.
Good morning, Mr. Cooper.
Good morning.
This is Madeline Bader. Can you hear me?
I can, Madeline.
Okay, can you see me?
I can.
See the world we live in? Okay.
Before we go further, your microphone on your desk, does it have a green light or a red light?
That's a red light.
If you would put your finger in that little indentation and then take it out, did it turn green?
It did, Your Honor.
Great. He'll be able to hear you even better now.
Okay. Mr. Cooper, can you hear me?
I can.
Okay, great. Thank you again for being here. I have a couple questions for you. Are you the property manager for the Briargate Townhome Association?
I have been the interim property manager for Briargate since 1st of July.
Okay, and who is your employer?
Access Management Group.
Okay, as the property manager, are you familiar with the accounting records, the accounting and the records of the association?
Yes, I am.
What are the responsibilities of your position as the property manager?
As property manager, our responsibility is to oversee maintenance and association fees, dues, anything related to the properties. We are over to manage, whether it's a homeowner association board request or responsibility, or it's a properties homeowners request or responsibility.
Do the responsibilities of your position also entail well, you mentioned it, the collection of association assessments from homeowners that are delinquent, or just any assessments, whether they're delinquent or not?
Any assessment is submitted to Access Management Group. Once they're done so, they're uploaded into the portal that I have access to, which is Vantica. So the software we have, I have access to, yes.
Thank you. Are the defendants lot owners within the association?
Correct.
Yes.
Yes.
And so can you please identify are you able to see my screen?
I am.
Can you please identify this document?
I can.
And Your Honor, just to clarify, this is Plaintiff's Exhibit number 3, which is
The
page 70.
declaration.
Yes, Your Honor,
Okay.
2 of 130. Yes. Sorry, Mr. Cooper, can you again just clarify what this is?
These are the declarations covenants of Briargate.
Okay, is the declaration, are these covenants binding on all owners within the association?
It is.
Objection to the extent calls for legal conclusion.
Okay, I will not take it as a legal conclusion.
Your Honor, may I continue?
You may.
Is this a true and correct copy of the recorded declaration?
This is a true copy, yes.
Does the declaration provide for the collection of assessments?
Yes, that is standard.
What is the purpose of these assessments? You alluded to it a moment ago, but what do the assessments do for the association?
Each year, the board is responsible for setting fees and assessments to manage their property, keep it up, take care of things that are either in the common area, non-common area.
So maintenance.
Maintenance.
If a homeowner is delinquent in the payment of assessments under Article 6 of the declaration, is the association allowed to recover late charges, interests,
That absolutely.
collection, reasonable attorney's fees actually incurred?
Yes, all of which you just mentioned.
Okay. Thank you. Give me just a second. I'm flipping now to page 61
Okay.
of the declaration. Can you please identify, I apologize, 62.
It's page 62 of the declaration,
I
which is,
apologize. Page 62 of 130 of the PDF.
but the declaration is at 72. So 62 would be before the declaration starts.
Correct. I'm about to enter a new exhibit into the record.
Okay, I'm sorry. So not of the declaration, of your overall deck of exhibits.
That's correct.
Got it. Okay.
Apologies.
No, it's all right. 62.
Correct.
Okay.
So I'll just set the foundation. Can you please identify this document, Mr. Cooper?
Yes, this would be a ledger that is reporting balances. Yes.
Okay, does it show assessments, late charges, and other amounts owed by the defendants?
Yes.
Is this a record made in the regular course of your business?
This would be absolutely. Yes.
Is it the regular course of business to make and keep such records?
Yes.
Are the entries recorded on this document made at or about the time they occurred?
They would be. Yes.
Is this a
Objection, hearsay.
What's the hearsay part?
The hearsay part is he has no personal knowledge of the timing or the accuracy of the making or the entry of the information shown on these records. So maybe it's more of a foundation, lack of foundation.
Okay. Well, when it's tendered, you can argue lack of foundation.
Yes, Your Honor.
Mr. Cooper, is this a true and accurate reflection of the principal amounts owed to the association?
Yes.
Your Honor, at this time, I am submitting page 62 of 130, the defendant's account ledger as Exhibit 5.
Exhibit 5. And is it just one page or is it?
It is page 62 and 62, 63, 64, and 65.
Okay. So the purple pages seem to indicate where their exhibit breaks. You're not including 61.
I haven't moved that one into evidence yet, but I would want it to come in as demonstrative.
Okay.
only.
So the exhibit you're tendering as Exhibit 5 is pages 62 through 65
Correct, Your Honor.
of your deck.
Correct.
Exhibit 5. All right, Mr. Colvin, you have an objection to the admission of what we're calling Plaintiff's 5.
Yes, Your Honor.
Okay, do you want to ask questions of Mr. Cooper about the exhibit?
I think I need to. Your Honor.
Let's do that. All right, Mr. Cooper, you're not done with Ms. Bader, but because there's a question about, there may be questions about this document, I'm guessing it's connected with the fact that you didn't become interim property manager until July, and these records are from well before July 2020. two.
Understood.
Mr. Colvin may have some questions about that. So I'm going to let him ask you a few questions just about this exhibit.
Yes, sir.
Good morning, Mr. Cooper. Can you see me?
Yes, sir, I can.
All right. I represent Mr. Habbassi. And so you had testified you've been the interim property manager since 7/1/22. Is that correct?
That's accurate. More like maybe July 6th, if we're going to be exact.
All right. And as a part of your preparation for your testimony today, have you spoke with any other individuals, including Patty Fan, about this file and the case itself?
I'm not sure, Patty Fan. I'm not sure.
Your Honor, objection. I don't know that that's relevant to the questioning. Patty Fan is someone who works in our office.
Okay.
Just to clarify.
Okay. Well, it sounds like Mr. Cooper doesn't know a Patty Fan anyway.
Yes,
Next
Your
question.
Honor. Yes, Your Honor. So in your testimony that this is a fair or this is an accurate representation of the account's status, of the account's balance of the entries into the account, what is the basis of your acquisition of the knowledge of that fact that those are accurate numbers and properly entered in a timely fashion?
Well, this is a industry standard of keeping ledgers on properties. The document I'm viewing is relevant to what we do as well. So assessing this transaction history, it seems to be in order.
So your statement that it seems to be in order is merely based upon your personal review of the ledger. Is that accurate? Yes, Your Honor. So again, my objection is that it's hearsay. He has no personal knowledge of any of the events that are shown here, any of the assessments, finds, anything. And I don't think that his testimony can be offered without laying a proper foundation for that. Otherwise, it's hearsay.
Your Honor, I'm happy to respond. Mr. Cooper, it's my understanding that there are no fines on this account. These are just general assessments that accrue every month. And
Correct.
that the declaration provides even for acceleration of all assessments that are due at the time that they become delinquent through the remainder of the year. So, these amounts are the same amounts that are imposed against every homeowner. And due to the acceleration, there's nothing special about the amounts that are imposed that would be specific to your chronology as a manager coming on at a particular time. And there are no fines imposed, correct?
Correct.
So there's an entry on February 18th, 2019, attorney's fees and expenses. That doesn't seem like it would be standard if I lived in the Briargate area and was current on my assessments. Would I also have a $350 attorney fees and expense entry?
You would not, Your Honor. However, I myself can testify to the imposition or to those attorney's fees are the same attorney's fees that I can stand in my place and ask for today. So if for some reason we want to redact those from the statement, it's fine to do so.
Okay. Is there a reason why your Exhibit 5 only goes through 2020?
If you look on, it actually goes through 2022.
Oh, it looks
Scroll all the
different.
way to page 5.
Got it.
Yes,
It looks different. So page 64, there's 2021. And then page 65 is up to now, the 2022.
And
Okay.
we do, just for the court's purposes, so that there is a full record showing the attorney's fees, having everything on the ledger is a helpful component for the homeowners to see what is actually being assessed. But if we're concerned that there isn't, knowledge on behalf of Mr. Cooper for those amounts, we can redact those from this exhibit, I'm happy to agree to that. But I will be testifying to them anyway in my place at a later time today.
So, Mr. Cooper, if you could look at, I guess you can only look at what's on the screen. Can you put page 65 up on the screen, please?
Okay.
Is that format that you see on the screen the format with which you're familiar for the homeowners association keeping a log of what each person owes?
Yes, sir. This is a document that would be from Access Management Group.
Okay. It starts out with a big old number at the top. Not the very first entry, but this carryover from 12/31/2021.
Yes, sir.
What are those entries?
The first entries would be forwarded balances that came from the previous property management company.
Okay. So it looks like through page 65, which this individual, I believe, can lay a sufficient foundation for without any hearsay issues, we get to the same numbers because they've got entries on them that carried over, I assume automatically because they were changing accounting systems or something that reflect the balances from page 64, which looks like it was a different software setup. And then pages 62 and 63, which were yet a different, it looks like it was homeside properties, which would, I guess, have been a different property manager at the time.
Correct, Your Honor. And due to the acceleration of the assessments, I'm just flipping to Article 6 to find that specific language, but for that reason, the obligation can extend through the actual calendar year. So even though there's been a change in homeowners association property managers, that Mr. Cooper is still, he and his company are still the agent for the association that can testify to these amounts that are owed.
Okay. Can you put 62 back up, please?
Yes, Your Honor.
Mr. Cooper, is what you see on the screen now something you've ever seen before in terms of format and contents in connection with this particular homeowners association?
So I haven't seen this document before. I just want to make sure I'm answering your question correctly.
Yeah.
This is standard format.
But when you say standard format, standard because of your work as the interim property manager for Briargate, or it's standard format in the industry?
In the industry, the format of the ledger and the transaction histories.
Got it. So I will admit page 65 of Exhibit 5 over Mr. I don't think Mr. Colvin's objection applies to page 65 based on this witness's knowledge and the foundation he's laid. So I will allow 65 in. 62 through 64. It doesn't sound from what I've heard from Mr. Cooper that he can lay a sufficient foundation for those. So I don't know how we need to reflect it, but there is now a plaintiff's Exhibit 5, which consists of page 65 from your deck, if that makes sense.
Yes, Your Honor. Makes perfect
And I'm
sense.
sorry, if I could just clarify, because it's kind of hard, Zoom documents back and forth, but are you sharing 65 right now?
I am not, but I will.
Would you mind
Sure.
trying to get to it
So
through
this
my
is page
documents?
65.
All right. Would you scroll up to the
Scroll
bottom?
Up or down?
Up, or yeah, I want to go to the bottom. All right. All right, so that's through 810. So to the extent, Your Honor, I would like to renew my objection to the extent that page 65 is inclusive of the numbers that occurred in the prior years, which this witness has absolutely no testimony, has laid no foundation as to the propriety of the forwarding of anything, of the 3/119 letter, of the 3/10/20 letter, of the conduct, the allegations of my client's running a business through the evidence of having multiple.
I don't know what you're talking about, but this witness has said nothing about your client conducting any business. I'm admitting page 65 as Exhibit 5. And you may be asking Mr. Cooper about some letter about your client running a business out of the property, but I'm limiting it to Mr. Cooper's knowledge as the record custodian for Briargate Townhome Association, that he is certainly in a position to authenticate and lay a foundation for page 65. It's less clear to me as to the other pages. We may revisit this if Ms. Bader asks him different questions or there's another witness, but through this witness, page 65 comes in as Exhibit 5.
Thank you, Your Honor.
All right.
Your Honor, to be clear, and I apologize for looking at my phone a moment ago, but we still have one person in the waiting room, correct?
Well, we've had two. Someone named Matthew's iPhone has popped in and out.
My associate.
Okay, I'm happy to let Matthew's iPhone in. Just
Be great.
let me see if Matthew's iPhone is still there. And then we still have so right now just Jesse Fleming is in
Okay.
there. If I see Matthew's iPhone, I'll drop
No worries.
that into the Zoom session.
Thank you.
There's also a YouTube feed going on. So if your associate is simply trying to watch
Oh,
what's happening, if people go to the court's website, click on my name, that gets to my stream and YouTube, it's live on YouTube.
all right, great. Good to know. Okay, so Mr. Cooper, just to be clear, Exhibit 5, you're seeing on the screen for the court, this is page 65 of 130 of the PDF that was submitted.
Yes.
So, all right, getting back to the amounts that are on this document. First, I want to talk about, again, the declaration, which we saw just a moment ago for the court's attention. That's Exhibit 3. In addition to principal, is the association entitled to recover interest on unpaid principal?
They are. Yes.
And is the association entitled to recover late charges? Backing up to the interest, is that at 10% per annum, according to the
Correct.
declaration?
Yes.
And
it is.
late charges, no amount more than $10 or 10% of each assessment due, whichever is greater. Is that correct?
That is correct. Yes.
Is the association also entitled to recover its reasonable attorney's fees actually incurred?
Yes, they are.
Okay, and so are the defendants, according to this document,
Okay. Okay.
we are seeking and now, of course, this is calculated out completely, but we're seeking $6,420 in principal, $594.50 in late fees, $827.50 in attorney's fees.
In interest?
I'm sorry, I apologize, in interest, $5,958 in attorney's fees, $437.07 in court costs and expenses, subtracting $21.75 for payments. So for a total judgment amount of $12,062.07, which I have a demonstrative exhibit, which aligns perfectly with this Exhibit 5 to show each month's input for all of those items, Your Honor.
I'm fine with demonstratives. But
Okay.
did you have a question for Mr. Cooper? Because you were sharing those numbers again.
Mr. Cooper, is that, to your understanding, the amount that is due, the total amount that is due on this account?
Yes, ma'am, it is.
Okay, Your Honor, I have no further questions from this witness.
Okay. Mr. Colvin, do you have questions for Mr. Cooper?
Yes, Your Honor.
Okay.
Well, may I question him from here since he's not at the witness stand?
You can, as long as that microphone is green, the light is green, you can be from there. You're welcome to be at the podium. You can, anywhere he can hear you.
Yes, Your Honor. I'm going to choose right here,
Okay.
standing up. Mr. Cooper, so have you reviewed the the letter of 3/1/19 to Mr. Habbassi and his wife?
I have not.
All right. Have you reviewed the letter of
Objection,
3/10/20?
Your Honor.
One second.
Did you want to show him the letter that you're referencing, or are you just asking him to recall?
He's asking the questions he asks. You will have a chance to redirect, and you may want to put a document in front of Mr. Cooper. But Mr. Colvin is asking now, and based on the way he described the document, Mr. Cooper says, I'm not familiar with that. That's how I'm taking this exchange. You can keep going, Mr. Colvin.
Yes, Your Honor. So, Mr. Cooper, your testimony is also that you have not reviewed the 3/10/20 letter either, have you?
I have not reviewed that document.
All right. Do you know what my client did in response to the allegations, or strike that? Are you familiar with the underlying allegations which gave rise to this matter?
Gave what to this matter?
Gave rise, resulted in this lawsuit being filed against my client and his wife. Are you familiar with any of the factual events that occurred leading up to the lawsuit being filed?
I am only familiar with the association fees and assessments not being paid. I'm not familiar with what you have asked the question of.
Yes, Your Honor. Yes, Mr. Cooper.
Okay.
Mr. Cooper, let me ask you this. Are you familiar with the portal from which Briargate Homeowners Association members log on to pay their assessments?
They have access to the portal. I do not utilize the portal from their side. I utilize it from Access Management Group side.
All right. So is Mr. Habbassi and his wife able to log into and access their account on the portal?
That would be an option, yes.
So is it your testimony that they could have logged in yesterday and done that?
Sure.
All right. So would it be a surprise to you if I were to tell you that in fact they cannot log in and they've been blocked from accessing the website?
That would be new to me.
All right. Who is Fleming? Jesse Fleming.
He's the HOA president, current.
The current president, do you know how long he's been the president?
Not off the top of my head.
Have you discussed this case with Mr. Fleming?
We have not. We've had minimal discussion about history, only that the account and the balance.
Only as to the account balance amount?
Each month we have a monthly HOA meeting,
Right.
and assessments is always going to be, delinquent assessments is always a topic within the HOA meetings.
All right. So did you review with Mr. Fleming in this short review anything regarding any notes or witness statements or videos or photographs or anything related to the covenant violations that were alleged in March of 2019?
No, sir.
As far as the numbers reflected on Exhibit 65
Okay.
relating to since your assumption of the duties as interim property manager on July 6, 2022, have you reviewed with Mr. Fleming the underlying basis for any of those charges?
No, sir, we have not.
Can you
All right.
take down, unless Mr. Colvin's asking questions now, so if you take your exhibits down, unless he wants something up, we can see
Right.
Mr. Cooper better that way. There he is.
Hereby.
Well, it was just 65. I'm sorry. Could you put 65 back up, please? Thank you.
And just point of clarification, that's Exhibit 5, Your Honor, I believe.
Correct. It's
And I'm
what
sorry, page.
currently Exhibit 5 is only page 65. So those terms are interchangeable,
Got it.
And if you
but
would,
that's not what's on the screen.
Yes, my apologies.
Okay.
And if you wouldn't mind, if you could just scroll down to the bottom of the page again. Thank you. All right, so looking at 65, we've got a late fee of $14.50. We've got attorney's fees per invoice 295410 dated 7/7/22 of 271, association fee of 145 and late fee of 1450. Have you discussed the accumulation of any of those fees with Mr. Fleming?
No, sir, I have not.
All right. Did you actually enter those records?
No.
Enter the information into those records?
Objection. This has already been discussed when entering this document into evidence, Your Honor.
I think I had.
I'm gonna let him ask the question. Go ahead. Overruled.
Did you have anything to do with the entry of the numbers for the late fees, the association fee, and the attorney's fees personally yourself?
Those are not in my job responsibilities.
All right. So are they someone's responsibilities within the association?
No, sir.
Are they? I'm sorry. Is there someone? That's fine. You answered a question. I didn't ask the question properly. Let me ask it again. Or the proper question, which is that under your organization's responsibilities to enter those fees?
That would be correct.
And who actually does the data entry for the fees?
That's within the finance department.
All right. I guess that's all I've got for this witness, Your Honor. I'm sorry, let me ask my.
Okay.
Is there anything else? Okay.
Any redirect?
Your Honor, I do just quickly want to touch base about the document, the March 10th, 2020 letter, and kind of go off of that. Mr. Cooper, is it your understanding that that when an account goes to an attorney's office, that procedures may change in terms of payment on the account?
Objection leading.
Overruled.
Okay, in what way and how can payments be made once an account goes to litigation?
Payments can be made through garnishment collections or
Can
payments
Don't interrupt the witness. Let him finish answering.
Okay.
payments made directly from the homeowner or from the collection agency themselves.
Can payments be made directly to the association's attorney's office?
Yes.
Do you ever direct homeowners who are in litigation to make payments directly to the association's attorney's office?
When they're in litigation, we prefer it to be done that way. Yes.
Does that have anything to do with the accumulation of attorney's fees and things that may not have necessarily been posted to an account?
That absolutely would be.
Objection, lack of foundation as to knowledge. He's already testified he knows nothing about anything prior to assumption of his duties in July of this year. So as far as the basis for that, he has no knowledge.
But he does. He wasn't asked specifically about numbers in this case, but structurally, if that's what could happen based on a requirement or a request or a direction that fees be paid to the law firm rather than directly to the HOA. So I'll overrule the objection.
Your Honor, I think that's all I have in terms of redirect.
Okay.
For this witness.
I've got recross, Your Honor.
Well, then I guess you should do it.
Yes, Your Honor. I apologize. I didn't mean to jump the court. Just wanted to make sure the court knew that. Mr. Cooper, have you any knowledge of your predecessors having advised my clients, the defendants, of their right to make this payment through any other means other than the portal itself?
I definitely cannot attest to that. It's not to my knowledge of what was done.
Yes, that's all I've got, Your Honor.
All right. May Mr. Cooper be excused?
Yes, Your Honor.
Mr. Cooper, thank you for your time. You're free to go.
Okay, so I'm done for the day.
As far as I know, you may have other things you need to do in life, but just not with us.
Good deal. Thank y'all.
All right. Take care. So if you could take
leave.
the share screen down. I will I assume Mr. Fleming is next.
That's correct, Your Honor.
All right. Mr. Fleming, if you can hear us, if you could start your video, please. All right, and if you could unmute.
Yeah.
Great. Can you hear us?
Yes.
Deputy Gordon is going to swear you in. You are the next witness being called by Briargate Townhome Association.
Okay.
Can you raise your right hand? Do you swear or affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you?
I do.
Lower your hand, state and spell your name for the record.
My name is Jesse Fleming, JESSE FLEMING.
Good morning, Mr. Fleming. This is Madeline Bader.
Good morning.
Can you hear me?
Yes.
Okay. And you can see me okay?
Yeah.
Okay, great. I just wanted to bring you here to ask a couple additional questions about the Briargate Townhome Associations and the defendants in this case, Mr. Mohammed, Habbassi, and Miss Naima Jabal. Can you tell us your role for the association, please?
I'm currently the president of the association.
Okay, and how long have you had this role?
Since January or February, something like that.
Okay, and how long have you lived in the community?
Since 2008, I believe.
Okay, are you familiar with the assessments that have been imposed against homeowners in the community?
Yes.
Is it your understanding that the association has turned this particular account, Mohammed Habbassi and Naima Jabal, over to the association's attorney for collections?
Yes.
And are you aware whether any fines were imposed on this account, or were they just general assessments?
I think there were general assessments and late fees.
Okay, but no.
Objection, lack of foundation. As far as, I think he's testified generally that he's familiar with the imposition of assessments. I don't think he's testified specifically as to his review and knowledge relating to this specific ledger. And then we get into, again, Your Honor, the prior 61 through 64, and then the court's limitation of admitting only 65. So if he's trying to get into prior to 65, Exhibit 5, page 65, then I have the same thing as far as objection, as far as hearsay. But
Well, your objection
lack of
was,
foundation.
okay, that's what your objection was. Mr. Fleming, how is it that you have come to understand that Mr. Habbassi and his wife have been assessed late fees in connection with not paying their monthly assessments, but they have not been assessed any fines?
That's what we talked about with our manager and with the lawyer. I think this was happening before my time on the board, so I wasn't there at that time.
Okay, so you know it because other people told you that.
Yes.
Okay, so I'll sustain the objection.
Okay, next question. Have you been a party to an agreement on behalf of the board to not impose fines? Have you yourself made any decision related to fines on this account, whether it's any agreement or otherwise? Have you directed our office to put fines on this account?
So well, before you answer, that was like 6 different questions. And one of them, I think you wanted a yes, and the other, because you flipped it around, you wanted a no. So you pick which one, and then you can ask another one after it.
Have you directed our office to impose fines on this account?
No.
Okay. Has, to your knowledge, the board as a whole directed our office to impose fines on this account?
Not that I'm aware of.
Okay. Are you aware of a March 10th, 2020 letter? And I'm sorry, when did you say you came onto the board?
I've been on the board for 3 years now.
Okay, so in preparation for this matter and in terms of the board's approval, are you familiar with a notice of intent to foreclose on the property that may have been sent by our office to the Jabals?
I'm not aware of that.
Okay. Are you aware of these homeowners making any payments directly to the association, but not to the management company?
No, I'm not aware of any of that.
Okay. Your Honor, at this time, I don't have any other questions for this witness.
All right. Do you have any questions for Mr. Fleming, Mr. Colvin?
Yes, Your Honor, if I may. Mr. Fleming, you had said that, did you personally make the direction to the association in your capacity as the president of the association not to impose any fines against all homeowners?
No,
Was it instead your testimony that you made the decision or the board made the decision? Can you clarify who made the decision regarding no imposition of fines against my clients?
I'm not aware of there being a statement like that.
I'm sorry, you haven't just testified that there was some type of direction given to the powers that be that no impositions of fines would be made on this account.
I thought I testified that I was not aware of any fines being levied on this account, but I don't think that it was a blanket statement that we agreed to not do that.
So do you have any knowledge regarding whether any fines have been imposed against my clients?
So that's what he's testified to. His knowledge is no fines have been imposed. You've helped me better understand that wasn't because of some edict from the board. Hey, let's not fine these folks. It's just based on Mr. Fleming's role, board member, president, et cetera. He's not aware that fines have been imposed or assessed, just late fees. And obviously they're the monthly assessments that everyone who lives there gets assessed.
Thank you, Your Honor. I
Sure.
appreciate the court's clarification. Mr. Fleming, you had said you've been the president since January or February of 2020. Is that accurate?
No, of 2022. I've been on the board.
2022.
Yeah.
Right. So prior to January or February of 2022, were you a member of the board?
Yes.
And what was your capacity in the calendar year, or the board year of 2021?
2021, I believe I was vice president that year.
All right. And then in 2020, what was your what denomination did you, or what title did you have as a member of the board?
I think that year I was a member at large.
All right. Do you have any recollection regarding any of the forwarding of the notice of violation of March 1st, 2019 to my clients?
I'm not sure what we're referring to here. I'm sorry.
Well, let me ask you this. You've been a member of vice president and now the current president. How are allegations of misconduct or violations of the covenants handled by the board?
When we're notified, we determine whether or not we think it's happening, and then we ask for the management company to send violation letters, and then they escalate those through the means set out in our bylaws.
All right. So have you reviewed or when the board is notified of a violation, is that recorded? Is that violation or that allegation of a violation recorded?
Objection, clarification on what recorded and what the context of recorded is so that my client can appropriately respond?
Well, you don't get to ask the questions right now. If Mr. Colvin is asking in a way that you think is awkward or is resulting in a misleading answer, you'll be able to redirect and clear that up. He chose the word recording, and if Mr. Fleming wants more about that word, he can say, I don't know what you mean by that.
Do you know what I mean by that, Mr. Fleming?
I'm assuming a paper trail of some kind.
Reduced to writing was going to be, I guess, the clarification. Was the alleged violation against my client reduced to writing regarding the contents or the allegations that he was operating his business from his townhome?
I have recollection of emails about it, yes, and shared with other board members and the management company at the time.
So these would have been emails that were exchanged prior to the issuance of the March 1st, 2019 letter. Is that your testimony?
I believe 2019 was before my time, so I'm not sure about that.
All right, so let me just clarify. You became a board member in 2020, a member at large. Is that your testimony?
Yes.
All right. So did you, were you aware that there was a notice to produce that was served upon the Briargate, upon the association for this trial?
I was made aware of that yesterday.
Okay. Did you happen to, or does the association still have these emails in its possession that were exchanged in 2019 regarding the allegations against my client?
Objection, Your Honor. These are related to a notice to produce that we think was defective and not timely made. And so I'm objecting to the fact that these, first of all, these documents are not being presented to my client to comment. They're not in evidence. And also these are legal arguments that are being made as opposed to factual statements requested from my client.
Yeah, I'm going to ask you, Mr. Colvin, to move to a different topic because Mr. Fleming has made clear he's not familiar with that situation. It seems to weigh heavy on you and your client. These letters that I haven't seen, they're not in the record. So you should ask a different question and let's move away from these two letters because Mr. Fleming has said he's not familiar with these letters.
Yes, Your Honor, but I believe his testimony was that he was familiar with the underlying emails that gave rise to the issuance of the first letter. Can I clarify with him if that was his testimony?
Okay.
Mr. Fleming, did you not just testify that you're familiar with underlying emails which gave rise to the issuance of the March 1st, 19 letter to my clients? Yes or no?
I'm aware of emails, not of how it started, but once I became a board member about following up and determining whether or not the violations were still happening.
All right. What knowledge do you have about the members, as a board member, the association members, the homeowners, specifically my client having access to the payment portal?
Can you repeat the question? I'm sorry.
Do you know if my clients are blocked from using the payment portal or not? Currently blocked.
I do not know. That would be something for the management company. I don't manage that.
Does the board give the management company direction regarding the blocking of members' access to the online portal?
No.
So who would make the decision to block access? Would it be the management company as per your knowledge?
I have no knowledge of that ever happening, so I don't know who would make that call or for what reason.
All right, so you specifically state that you have no knowledge regarding the access being denied to my clients to the payment portal?
That's correct.
All right.
Any redirect?
No redirect for me, Your Honor.
Okay. May Mr. Fleming be excused.
He may.
Mr. Fleming, thank you for joining us. You are free to go. Have a good weekend.
Thanks, you too. Bye.
Okay.
All right. Do you have any other witnesses that you intend to call or other evidence that you want to present?
I
Ms.
do
Bader.
have, yes, Your Honor.
Okay.
Apologies for interrupting. I do have a demonstrative exhibit that I would like to enter into evidence. That is on page 60 of 130,
Okay.
Your Honor. That would be Plaintiff's Exhibit 6. And this is a complete outline on a monthly basis of how all of these charges were accumulated and calculated.
Okay.
Your Honor. Let's see. And that is, Your Honor, that is the only document that I'm seeking to include at this point. So plaintiff side rests at this moment.
Okay. Mr. Colvin, any evidence you want to put on?
I do, but I have a motion.
Okay.
Your Honor, I move that the court dismiss this claim as it has not been proven in any way, shape, or form regarding the underlying factual basis which these numbers are derived from. So the court may have admitted plaintiff's 5, but the court has not been provided any evidence regarding the allegations or conduct which led to this. I believe, Your Honor, that the blocking of the portal is because
So I don't have any evidence that the portal was blocked. You've said it,
All right.
but there's
Well, I'll proffer to the court.
You don't need to-
put my client.
proffer anything right now, just so you know the state of the evidence.
Right.
I have evidence that your client, for whatever reason, when I say client, both your clients, have failed to pay their monthly assessments for several years.
Right.
No fines have been imposed. Late fees have been imposed. Interest has been assessed. Attorney's fees have accumulated and court costs. So the only evidence I have is that there is an obligation to pay, and there are consequences for not having paid, which could include the judgment of foreclosure up to the amount that is owed. So I've heard you talk about the blocking of the portal, but those words always came out of your mouth, which of course is never evidence. As we stand now, I'm going to take your motion as a motion for a directed verdict rather than dismissal.
That's what I meant.
And I'm going to deny it based on the state of the record, but I will then renew my invitation to you. If you want to put on any evidence, I'm happy to receive that evidence.
Yes, Your Honor, and I'm sorry, but the court, I had not finished making my presentation. If
Okay.
I could just add to this to perfect the record, of course.
If you're going to add evidence and not, hey, I think if I put on record evidence, it would look like this.
It's argument.
Okay, then keep going.
And the argument is that under the authority of Abdullah versus Winslow at Eagles Landing Homeowners Association Court, 349 Georgia App 615, that while the fines issue, I guess, has been laid to rest, I believe that Abdullah also stands for the authority that the amount of late fees, the amount of attorney's fees, that there should be more information contained within the declaration and the bylaws in that regard as well. And that information is not there. So I believe that Abdullah mandates that the court direct that verdict in my client's favor, as well as I wanted to reference 44-3-223. And actually, Your Honor, this is, I am going to put Mr. Habbassi up. I'm going to proffer that he is going to testify regarding all the things that I've been talking about and speaking to, especially the portal access. But under 44-3-23, 223, I apologize, 44-3-223, compliance with association instrument and rules and regulations enforcement. And it states in the, it would be the believe the last sentence. If and to the extent provided in the instrument, the association shall be empowered to impose and assess fines and suspend temporarily voting rights and the right of use of certain of the common areas and services paid for as a common expense in order to enforce such compliance, provided, however, that no such suspension shall deny any lot owner or occupants access to the law owned or occupied. So it's my interpretation that this action without the meeting the dictates of Abdullah is seeking to not only deny my client access to his lot, but it's seeking to take his lot from him through the foreclosure of a lien under the statute, and therefore cannot lie and should be, the court should find against the plaintiffs in this action upon that basis.
Got it. Thank you. I'm actually familiar with Abdullah because I had another homeowner's situation where fines were in fact assessed. I think it is distinguishable here because I have no evidence that the homeowners association assessed fines, and I may hear that they did, but more critically to your concern, nothing in what is being sought now consists of a fine. Abdullah stands for the proposition, and it did fit pretty well in this other case I had, that an association can't willy-nilly come up with what a fine amount would be. There needs to be clear authority in the declaration that the association can impose fines for what and their amount. In Abdullah, he installed a flower bed with that. Seems not like a very harmful event, but he didn't get pre-clearance for this flower bed. And so he was charged $100 a week for having this alleged covenant violation. His argument to the Court of Appeals was there's nothing in the declaration that authorizes the homeowners association to impose a fine. And just like you, he pointed to 443223, which empowers the imposition of fines if and to the extent they're provided in the instrument, meaning the declaration. All true. I don't disagree with any of that. But we're not talking about fines here. There may have been fines, and that may have been some tussle that your client had with the association, maybe even with the law firm, but that's not what's before me. It is unpaid assessments. And what you haven't shown me is that the declaration, and I don't think you can show me, that the declaration does not authorize the collection of assessments. Abdullah is not about assessments. Abdullah is not about late fees. It's not about interest. It is about attorney's fees because part of the attorney's fees were linked to this fine, but we don't have fines. So I distinguish Abdullah from this case and invite you to call your witness.
Yes, Your Honor. Without belaboring the point, I just would like to make sure the court understands that the last basis is that they have not factually established through their witnesses the necessary evidence to obtain this amount of fees, late fees, attorney's fees, assessments, because neither of their witnesses have any knowledge. The court excluded pages 61 through 64 on a lack of foundation and knowledge. So I would assert that as well, but I'll call them. I'm positive courts still deny my motion, but if I don't perfect the record, even as inartfully as I've just done it, I've still got to do it. So thank you for your considerations and allowing me to do that. I call Mohammed Habbassi to the witness stand.
All right, Mr. Habbassi, come on up, please. And I need to do one thing before you start your testimony. I didn't know we were going to have witnesses in here. I need to turn that camera back on.
That's a failure on my part to notice that or make sure the court was aware of that. I apologize.
It's all right. You can go ahead and swear him in. I just.
You swear affirm that the testimony you will give the truth, the whole truth, nothing but the truth so help you.
Yes, I do.
Your name, state and spell your name for the record.
My name is Mohammed Habbassi.
Who are you married to, Mr. Habbassi?
Naima Jabal.
Is she also a named defendant?
Yes,
Are you here speaking on her behalf as well?
yes.
All right, and just a little background on information on you. Are you a U.S. citizen?
Yes, sir.
And when did you become a U.S. citizen?
2015,
When did you come to the U.S.?
2008,
Where are you and Ms. Jabal from?
Morocco.
All right, and what is your what do you do for a living?
Right now is an auto broker.
A what?
Auto broker?
Auto broker?
Yes.
What does that mean you do?
And how long have you been operating as an auto broker?
By myself, I got my license in 2016.
All right, so what are the requirements of your license related to the conduct of business?
You gotta have an office with the desk and phone number, like a landline.
All right, and have you maintained an office since 2016?
Yes, of course.
I would turn you to, I need to get to the document and then share my screen. Your Honor, I'm not sure I've ever successfully done this, so I'll give it my best shot here as soon as I get down to that in my exhibits. All right. All right, look at there. I've done it. All right, Mr. Habbassi, I'm going to draw your attention to what I have marked as plaintiffs 7. Can you look over that document and let me know when you're ready for me to scroll down so you can see the entirety of it?
So I'm confused. You're calling it plaintiff 7.
I'm sorry, I said plaintiffs 7. Defendant 7, Your Honor.
Okay,
Yeah,
so I
but-
have some exhibits you already submitted to Ms. Niles, which means then that Ms. Bader would have them as well, but there's no 7 in there. What should I be looking in?
I had actually, I believe, submitted 3 batches to Ms. Niles.
Okay,
So it would be, let me get out of here and go to
the
my,
name, I have something, it's exhibits, it says 1-5, 1-6, and 4.
it would be, I believe, under 1-5. Although it says 1-5, but it should have included that document as well.
Okay, well, as long as Ms. Bader has seen whatever you have on the screen, I'll just follow along with what's on the screen.
I do, Your Honor, and I have it in front of me. as
Okay.
well.
Thank you, Ms. Bader. All right, so Mr. Habbassi, scrolling down, do you recall this document? It's page 1 of 2.
This is Regis. This is my first office.
All right, so would that have been a billing statement from Regis for your location of your first office?
This was in this is
All
Central
right.
Phoenix location.
I need you to get closer to the microphone so the court reporter can hear you. Thank you.
Yeah, this is my first office, and then this located in Sandy Springs.
All right, so the second page is the second page of the billing?
Yes.
All right. All right, moving, okay, that's the only that for that. So how long did you have an office at Regis?
I believe it was 2 years, 2016 to my renew, because we have to renew license every 2 years. So I moved from this location to what I'm at right now, which is Alpharetta.
Your Honor, apologies. I don't know if that document has been submitted into evidence.
Not yet.
It hasn't. So if we're going to do a whole lot of talking about it, it ought to be tendered since it's up on the screen.
All right, I'm sorry, I moved on, but yes, I would move to tender 7.
Any objection to defense 7?
I do object, Your Honor. First of all, relevance. I don't think it's relevant to the issue we're discussing here today of assessments. I also don't know if that's the proper foundation to be set up for that particular type of document that's pulled from the web. I don't know if there's a way for this witness to testify to the accuracy of that exhibit.
Can you go back to 7?
Yes,
I
Your
assume
Honor.
that's what we were
Yeah,
talking
I
about.
will.
Thanks.
So, Your Honor, my response would be that the document is a billing statement that was sent to him. He's testified to that. It has his credit card information on it. It's something that was created out of in the usual course and conduct of business.
I think that he can identify it and sufficiently authenticate it because it's what he was paying. What about the relevance? This
Well,
is,
the relevance. I'm sorry, I didn't mean to interrupt.
well, I guess I'm done. What's the relevance?
Well, the relevance, Your Honor, is that if the court will call on the demonstrative exhibit that was submitted, at the bottom of that is the list of the charges. The first charge is the assessment from 3/1/19 to 2/28/20. And that is then brought down or shown as an unpaid assessment, but then a credit is given for it for that same amount, for that same time period. And I'm trying to establish that there is some connection between them being, payments were collected then, or that's what I'll proffer his testimony would be. He made those payments online, and then there was a reason that those payments were not then collected. Now, he's going to testify as to his not limited knowledge as to that, but the plaintiff has not established any knowledge for that. So the relevance is we're talking about blocked access to portal. We're talking about unblocked access initially. There's been no basis to establish why those have been set out and differentiated as if they were paid late, because they weren't paid late. The evidence is that they were paid on time.
And having an office in Sandy Springs and paying for it is relevant in what way?
And I believe that the underlying basis for blocking him from the portal was that he was alleged to have been running a business out of his home.
Okay, maybe we have no evidence of that, but I don't understand what we're doing with this because he said that wasn't his office anymore.
Right. It's just showing that he had an office prior to 2018 at another location.
Okay, I'm going to not admit it because I don't think it's relevant. He can tell us he had a different office, but we're 2019 forward, whether Mr. Habbassi was in Trump Tower in 2017 or the GP building here in 2018.
Gotcha.
Not relevant.
Gotcha, Your Honor.
All right,
I'll move on.
great.
All right, moving on then, Mr. Habbassi, to Defendants 3. So I identified this as, have provided it to opposing counsel. Can you testify as to what this is?
This is my current office.
This is what?
This is the statement for my current office.
Your current office.
Yes.
And where is that current office located?
It's 11080 Old Roswell Road in Alpharetta, Georgia 3009.
And when did you start renting that office?
In 2018.
And were you renting that office in and around February of 2019?
Yes, of course.
And you've continued renting that office to this day?
Yes.
And this ledger was provided to you by whom?
I'm sorry.
Who provided you the ledger? The exhibit? If you look at the screen?
But this is the website I use to pay. Excuse me. This is the website I use every month to make the payment.
Is your landlord HZG Properties LLC?
Yes.
All right.
Ms. Bader?
Your Honor, I have an objection again to relevance here. If this is not related to the homeowner's assessments, but instead related to Mr. Habbassi's business. Also, the proper foundation has not been laid. Mr. Habbassi does not create this document for the course of his business. This is something that appears to be created by HZG Properties.
So your response, Mr. Cole, you don't need to respond to relevance. You've helped me understand. I find that testimony about Mr. Habbassi having an office for his auto brokerage is relevant. And
Yes, Your Honor.
that office is not, according to Mr. Habbassi, at Briargate. This document, I'm not sure that this witness can lay a foundation for it that would make it not hearsay.
Yes,
That
Your
doesn't
Honor.
mean he can't testify. Hey, I've been paying $300 a month, whatever the number is, since 2018. I'll accept that and keep that in the record, the testimony, but I'm not inclined to admit defendants 3 through this witness.
That's fine, Your Honor. Your Honor, would the court mind if we took a break, a short break? We've been going in about a little over an hour and 20.
Okay. Why don't we be back here before, I'm looking at that clock. I'll be ready to go no later than 10:45.
Yes, Your Honor. Thank you.
Okay. Mr. Abbasi, you can step down, but don't go far.
If you'll step out, Mr. Brown.
Lock my computer. Hang on just a second. Nobody's gonna go. Okay. Thank you. Okay. Would you come here? Oh, okay.
Are there bathrooms on this floor? I know they're redoing bathrooms all around the building. Good.
Excuse me, Sheriff. Someone here asking where they want it to go. Thank you.
What is what?
People that get this for the fucking me from using the never showed it to John.
And probably you can testify about it. Well, it might not be admissible, so for the same reason that the other stuff was. So remember, I was able to keep out a lot of their records because of me. Do what?
You didn't bring it?
Would you let me find it?
Okay. Because I was trying to log in.
Yeah, there's not a lot of documents in this case. Yeah.
When you showed him the fridges,
Right.
he didn't take it because that was old.
Yeah, because it was prior to.
Right. What about the new one? You have to tell him.
He received your testimony. Don't worry about that. Let me just focus on this. We got it in through your testimony as evidence as well.
I need to go back there.
Yes. We got 3 minutes. Just as the judge is ready.
You got like 1 minute.
1 minute.
All right.
Mr. Abbasi.
Hold on one sec. Ms. Jones, you still with us?
Yes, I am.
Great. We just took a little break, but we're back. We still have Mr. Habbassi on for direct examination in the defense portion of the case.
Mr. Abbasi, how have you made your payments, your assessment payments over the course of the last, but prior to March of 20?
To the website.
And when did you start using a website?
If I remember, it was January 1st, 2013, when I make the first payment, because when I purchased my house, they said you don't have to make the payment until the next year.
All right. So you began making the payments January 1st, 2013.
Yes.
And how long did you make the payments via the association's portal?
Until when I received the second letter.
And when was that?
It was March 10, 2020. I received a letter that says that they're
So
going.
don't read from a document that's not in evidence. You got a bunch of papers in front of you, and I don't know what Mr. Colvin handed you, but you should close that folder up. If he's got questions, he can show you a document, put something on the screen. Thank you.
All right, Your Honor, we're going to mark this as Defendants 1. This is the letter. I need to share screen.
You are sharing the screen right now, and it's
Oh, wait,
showing
I'm
this.
sorry. I'm showing a new share.
Okay, you got it in the old one if you want to share something new.
Okay. Pause share. It says pause share. New share.
So you need to end.
Yeah, I understand, Your Honor.
There you go. Okay.
Okay. All right. So is this the letter that you're referring to, Mr. Habbassi?
Yes.
And could you review that letter, that first page, please?
Yeah, this is the letter. I got scared because.
All right, hold on a second. My direction to you is to review the letter first before you begin to testify about it. So read that.
Not
Quickly.
read it out loud, just read it to
Don't read
yourself.
it out loud. Read it to yourself. And when you're ready to read page 2, let me know and I'll scroll down. You read the rest or review the rest. Are you ready?
Yes.
All right. So is this the letter that you were referring to?
Yes.
And what was your testimony then about continuing to make the online payments?
Yeah, I stopped making the payment on the 2020, March 10, when I received this letter, because I received an email. They said they changed the website for making the payment. So I get scared, like all this, it's been a year and they said I did not pay. So I was like, where'd the payment go? So I have to stop the payment for the old website. And when I sign up for the new website, I find myself locked until today.
And
Stop for a second. Yes, ma'am.
Your Honor, just a quick question. Has this been tendered into evidence?
It has not. So let's take it off the screen unless you're going to tender it.
I move to tender it as defendants one.
Any objection to the admission of defendants one?
I actually have no objection.
All right, it's admitted. Defendants one is in evidence.
Thank you, Your Honor. Mr. Abbasi, looking at page 1 at the description, would you tell the court what or just identify for the court the first entry?
It's a
I can read it. You
All
know, I
right.
need to describe it.
All right, I don't want to lead him though, Your Honor, but Mr. Habbassi, can you explain then at the before the total amount due of $976.48, that the payments in italics, it says less payments posted from 2/1/2019 through 3/1/2020. Can you explain why those payments are shown as an entry and then shown later as a credit?
that thing I didn't understand it too. That's why I was asking myself why they collecting payments, and they said I'm not making the payments.
Did you make the payments timely between February 2019 and March 2020 of your monthly assessments?
Yes, and I have an auto pay.
All right. So what did you do? Or was it, has already been your testimony that you stopped the auto pay because you were informed that you had to sign up on a new website to continue making your payments?
Say that again?
Did you sign up on the new website to continue making the payments?
Yes,
Did you stop the auto pay because they changed the website and you weren't set up on that website yet?
yes,
Did you try to resume the auto pay after you went to the new website and try to log into it?
yes.
All right. When's the last time that you tried to log into the website?
Yesterday,
And what happened yesterday?
I find myself still blocked from making the payment.
Was the response blocked? Did it say blocked?
It says blocked on it.
All right.
It says on multiple places it's been blocked.
All right. Let me ask you about the March 19th letter. Would mark this, or we're going to mark this as defendants 2, Your Honor?
Before we go any further, do you have any objection, Ms. Bader, to the admission of defense 2, which is the March 2019, so 1 year earlier letter?
I do have an objection to this letter, Your Honor, because it relates to a notice of covenant violation and not the matter that is currently before the court.
Okay, and so your objection is,
My objection is this letter is not relevant to the non-payment of general assessments that have accrued for 19 and 20 on this particular
Got
this
it.
homeowner's account.
what's the relevance of the March 2019 letter, defense 2?
The relevance is, Your Honor, that it goes toward our explanation or understanding why my client was denied access to the portal from March 2020 forward, as well as to why the assessments are shown in italics on the subsequent letter. And the subsequent letter, which hasn't been admitted, which was not objected to, is in furtherance of this initial letter. So it's certainly relevant to our overall defense, and it's relevant to the March 20th letter, because you don't get to the March 20 letter without sending this letter first.
All right, I'll let it in, but I do want us to stay focused, not on fines. There are no fines that the plaintiff is looking like it's trying to collect in the current action.
And again, Your Honor, I would just reiterate without belaboring that we're saying that he made his payments from March to March 19 to 20, but then he was locked out. They haven't established why he was locked out. They want to assert other ways to make a payment, but we've established through his testimonial evidence that since 2012, and even after this March 1st letter was sent to him, he was allowed to continue making payments up until March of 2020. So that's a part of our defense.
Understood. It's not
But
about fines.
But I'm not going to belabor it because I don't have to rebut any testimony because there was none offered because none of their witnesses have any knowledge of that.
Okay.
So is this the letter that you received, Mr. Habbasi, regarding the allegation that you were in violation of Article 8.3 of the Declaration by conducting business from your home.
Yeah, this is the letter.
Were you conducting business from your home?
No.
Did you respond to this letter?
Yes, I called the lawyer. I called Patty. I think her name was.
Okay, you can't tell me what she told you about that. But after your call, or I'm sorry, what was going on during this time? Was your on March the 2nd, did you find out that your father was in Morocco and dying?
Yes, it was March the.
You spoke to your mother on March the 2nd.
I spoke to her on the 2nd, and I had a ticket to go to Morocco on the 10th, but I have to change it because he was dying, and I changed it to the 6th, but he died on my way to the airport.
He died before you left for Morocco?
Yes, but I already called, for my understanding, I spoke to the attorney about this letter, and they told me if you.
No, you can't say what they told you, but what was your understanding after, and did you make this phone call on March the 4th, you said?
On Monday, it was March 4th, on Monday.
Do you believe it was with Patty Fan?
I believe so.
And your understanding of the situation regarding the assessments is what? From that call? I'm sorry, the alleged violation of the covenants. What was your
For
understanding?
my understanding, the problem was fixed, like it was taken care of, like it's done.
All right. All right, so did you hear anything else from the association about this assertion of a fine for operating your business?
No.
All right, what was the next, was the March 10th, 2020 letter the next time that you heard from anyone regarding that?
Yes.
And during that time period between February 1st, 2019 and March 1st, 2020, you were allowed to access the portal and make your payments as you had done for the previous 7 years.
Yes.
All right. I think that's all I've got. You know? Subject to redirect.
Do you have any questions for Mr. Habbassi?
I do, Your Honor.
All right.
Mr. Habbassi, you live in the Briargate Townhome Association.
Yes.
You've lived there since at least November 6th, 2012.
Yes.
You live there with your wife,
Yes.
who is Miss Naima Jabal.
Yes.
She's also lived there since 2012.
Correct.
You testified that you received a violation letter related to running a business from your home in 2019.
Yes.
You testified that you also received a notice of intent to foreclose from our office in March 10th of 2020.
Correct.
You testified at that same time that you were, and I don't want to put words in your mouth, but what was your feeling when you received this March 10th, 2020 letter?
I got scared.
You got scared.
Mm-hmm.
And is it your contention that you paid the total principal amount due for 19 and 20 to the association?
The $2,030.
$2,030.
I was paying that. I already paid that.
Okay. Did you, to your knowledge, pay any interest that had accrued on your homeowner's account?
I believe I was paying the monthly payment plus late fees.
Did you pay any attorney's fees that had accrued on your account?
None of something I'm aware of. They never told me to pay the attorney fees.
So when you made your payment when you paid your assessments and you noticed that your account was blocked, did you see that there was a balance on your account prior to the account being blocked?
No, there is it says block. There is nothing, no current fee, no due something, nothing.
Now, I would like to show you what has been marked as defense 1, which is the March 10th, 2020 letter. If we could have that up on the screen.
I think I had it.
Is that up there now?
I
Well,
believe-
it'll be easier if you'll stop sharing,
All right.
Mr. Colvin.
Yes, sir.
That'd be great, because I think you've got it in your exhibit world, but we'll still call it defense 1.
Sure.
But that way, Ms. Bader, you can scroll where you want to scroll on it, and you're not having to
Of course.
talk about, I meant up, not down, et cetera.
And if you'll stop sharing.
Yeah, I'm trying to. Can you help me? I mean, it says resume share, new share, pause share.
I think you have to actually stop. See that red block? right
There you go.
Yep.
Thank you.
There we go.
The old man appreciates it.
Yeah. It's a new world we're living in.
Oh, yeah. And then start stopping.
All
Turn.
right, so. Okay. Mr. Habbassi, can you see my screen here?
Yes.
Okay, I'm referencing this March 10th, 2020 letter. Just so we're aware, do you see at the very bottom of this letter where it says, please note pursuant to 6.2, well, first of all, do you see that it says total amount due?
Yes,
976.48. So there was still a delinquency on your account, the plaintiff alleges, after you made the 2030 payment, the payment for $20.30.
Well, it's $2,030.
$2,030. After you made that payment, this letter still shows that you owed $976.48. Is that what the letter says?
this is what this letter, that's what, I can see that.
Okay.
But
does
this is the first time I see this one was on when I received this letter. I never see attorney fees or any other fees before.
Okay.
They never send me anything
And you said your account was locked after this letter.
after March the 20th. Yes.
Okay, so I'm showing you now page 2 of this letter at the very top. This says, please remit your check payable to Briargate Townhome Association, Inc. and mail it to Coulter and Sierra with an address at your earliest possible convenience. You may also remit payment online by using our website with a link. Do you see that statement?
Yes, I see that.
And that was in the letter that you received in March of 2020.
Yes.
Okay,
So
but go ahead. Your testimony is you didn't make a payment after you received this letter.
I'm talking about the monthly payment for my association,
Right,
not for the attorney.
right. But you didn't make a single payment to the association from the date of this letter until today here in court. You have not made a single payment to the association.
Yes, because the website was blocked.
Okay, but you also did not make a payment as directed in this letter.
I did not make the payment. You want me to send a check to Briargate Townhome? Is that what you're telling me? Like
I'm
if
asking
you
if you
were
made-
blocked, if you were
Don't
blocked,
talk over each other.
Sure.
sorry.
Keep
Go-
going,
go
Mr.
ahead.
Habbassi.
If I was blocked from making the payment from the website, I should send a check to either Briargate or, to the attorney pretty much. But why would I make the payment for something I already pay?
So let me ask a question. You owe homeowner assessments every month, is that right?
Yes.
Let's pick February 2022, so 6 months ago. Did you pay your February 2022 monthly homeowner assessment?
No,
Why not?
because I'm blocked from the website.
So what steps did you take to figure out another way to make a payment than through the website?
I called the office,
What office?
the Briargate Townhome,
Okay,
but nobody answered the phone. And I start calling since I received this letter. Now, from I received this letter. When I find myself it was blocked, I make multiple call to the office, but because I believe, if I remember, it was because the COVID, everybody was out of the office, so nobody answered the phone.
Okay. It is in fact the case that since you got the letter that scared you, I understand why it scared you, in March of 2020, you have made no payments. You've tried, but the portal is blocked. And you've made some phone calls, didn't get an answer. That's what you've done in your effort to try to pay, not necessarily this past due amount, but the ongoing amounts. Is that also true?
No, I never refused to make the payment. I always try to make the payment.
Okay, but you haven't actually made any payments.
No, we just keep adding. It's not my fault. I mean,
I'm
tried.
not blaming anyone. I just want to understand, you hit the payment portal, it says blocked. And so you just try again the next month when the next amount would be due.
It was still the same.
Okay. And so for every month since March of 2020, each month you've tried to go to that portal and tried to pay,
Yes,
and it's been blocked every
been
time.
blocked until yesterday night.
Okay.
But the thing that bothers me that day when I see this second letter, it was the foreclose. They're gonna foreclose the house, plus the attorney fee. The attorney fee, they never mentioned it before. Even the first letter, they said on the bottom of this second letter, if you go down, you'll see we send you attorney fees. They never send me any attorney fee. How do I know that I'm supposed to make this payment for the attorney fee?
Okay. Well, eventually you got a lawyer and you and your lawyer could talk
That's the
about all
reason
that.
when I hired him. That was after this letter.
Okay. You can keep going.
I don't have any further,
Let me just redirect you.
Okay.
Mr. Habbassi, it should have been your testimony just in examination by the court or questioning by the court that you contacted, when you got this March 10th, 2019 letter, Defendants 1.
objection, just a point of clarification.
Are we talking about 2019 or 2020?
I thought I said 2020.
You said 2019.
I meant March 10th, 2020. The letter
Okay.
dated March 10th, 2020.
The one about the attorney's fees.
The one, yes, that made reference to the attorney's fees that set out the arrearage for the payments that he had already made, the 2030 in disputed arrearage. Mr. Habbassi, how many times did you contact the HOA about, I'm sorry, strike that. How many times did you contact the law firm about this matter?
I mean, the attorney or the office, the HOA?
Well, I would need to know, the judge needs to know each as best you can. You just generally said you called them, but can you clarify for the court, did you call the law firm, Sierra and Coulter, the plaintiff's counsel, in response to this March 10th, 2020 letter, Defendants Exhibit 1?
No, I did not call them.
All right, what did you do instead?
When I see this letter, I stopped the payment from the old website for me to open the new website and make the payment on the new website. Then when I disconnect the old website and open new one, I find myself is blocked.
And did you contact Briargate Association to try to get it unblocked?
Yes, I did.
And how many times did you contact them?
I don't remember how many times, but there were a lot, like pretty much twice a month.
Was this after you had retained me and been sued in October of 2020?
Yes,
You continue contacting.
I continue contact them, but they never answer the phone.
Did you leave messages to them?
I don't remember. I leave message. I may leave messages, but
Did you leave one message?
maybe, yeah, I think so.
And you never got a response from
No.
them? The website was never unblocked.
No,
So even though there were other forms of payment, the one you had been making since 2012, or the method you'd been making successfully since 2012, you attempted to continue doing.
yes,
And you never given an explanation as to why.
no,
Were you ever given an explanation, any further explanation regarding the the 2030 arrearage that was alleged in this letter?
No,
You made reference to the attorney's fees in the first letter. Is that correct?
yes.
All right, so Your Honor, I need to. If I can, sure I can.
Do you want, you're going to share something?
I was going to share that.
To unshare, stop sharing, please, Ms. Bader.
Let's see. I'm sorry, Your Honor, I've got to bring that back up. There it is. All right. All right. Well, there we go. All right. So is this the letter then where you referenced, or you're saying that the March 10th letter made a reference to the attorney's fees?
This is the first letter.
Right. Is there attorney's fees, an amount of attorney's fees shown in this first letter?
I don't see no attorney's fees in this letter.
All right. So what's the confusion then?
The confusion, they said that they mentioned it on the second letter. They said
right.
they already tell me about how I have to pay the attorney fees.
All right. So this is the second letter, Defendants 1. Are you referencing attorney's fees that's shown under description and amount being $555.30?
The first time I see it was on this letter.
Right. And
It's up.
and there's a reference to attorney's fees in the letter?
Yeah, you go up.
Is it in the first paragraph or second paragraph on the second
The
page?
first one on the first page.
Okay, where else
Right
is
there,
there?
on the bottom. Please note, person article.
Article 6, section 6.2.
Yeah, keep going until the bottom.
Okay, as you are aware, our office previously sent you correspondence on March 1st, 2019, which your incurred attorney's fees. So that's awkward, but you understood that to mean that there was attorney's fees amount shown in the March 1st letter. Is that accurate to your testimony?
Yes,
And you've reviewed the March 1st, 2019 letter, Defendants Exhibit 2, and there is no attorney's fees stated.
no, there's no fees mentioned.
All right. Do you understand what incurred means?
Not really.
All right. Your Honor, I move to admit Defendants 1 and 2.
Okay, I think they're in, but they're doubly in now.
That's all I've got of this witness, Your Honor.
Okay.
All right.
Ms. Bader, anything?
I'm sorry, could I just take one moment?
Okay.
Could I just have a second? Mr. Habbassi, is it your understanding that under the description on the March 10th, 2020 letter, Defendants 1, that the additional fees were related to this allegation that you had been doing your business out of your home? Is that your belief? That this $976.48 in additional costs was related to that?
Yes,
And your understanding was that you weren't going to be charged anything for any of that because
what
you
my-
addressed it?
That's from my understanding when I called the attorney office, when I first received the first letter.
All right. So I've got your.
Okay, any recross?
Recross, Your Honor. Mr. Habbassi, you've owned the property at 2230 Kilmington Square since 2012.
Correct.
You made some assessment payments on your account to the association from 2012 forward.
Yes.
But when you received this letter on March 10th, 2020, you stopped making payments to the association.
I did not stop it. I was trying to switch it to the new website.
Mr. Habbassi, did you or your wife, to your knowledge, make your monthly homeowner's assessment payment last month?
Did we make the payment last month?
Correct.
Which
Did you
right-
make your payment for last month, the one that accrued last month?
No, we did not.
Did you make the one that accrued for 6 months ago?
No.
Have you made any payment on your account since March 10th of 2020?
After we get blocked, we never make the payment.
Did you ever tell Mr. Colvin, look, here's the money, just get it to the lawyers on the other side? I don't want you telling me what he said. I just want to know, did you ever get it that you say the portal didn't work, made some phone calls, didn't get an answer? Did you ever say to Mr. Colvin, we've got the money. I've been setting it aside each month. I've been trying to pay. Here is, I'm making the figure up, $5,000. Would you please give it to the lawyer on the other side so that we can move on?
I was gonna do that, but the attorney fee, what it bothers me too much.
Okay. Meaning not Mr. Colvin's fees, but the
no.
attorney's fees that you see here.
Yes.
Okay.
No further questions.
Briefly, Your Honor.
Last question.
Last question. Did you try to settle this case by paying money, offering money to the HOA,
Yes.
substantial amount of money?
Yes.
Did you put $2,000 in trust
Yes.
in my account in order to do that?
Yes.
Was that accepted by the association under any agreement?
Did I accept it?
Did they accept it?
I don't think so.
All right. So I got Your Honor.
Okay. Thank you, Mr. Habbassi. You can step down. Any other witnesses?
No, Your Honor, the defense rests.
All right. Ms. Bader, if you want to make closing argument, you can.
Your Honor, I do, just briefly. I know, I'm sorry. I'll try to be as efficient time.
No, that's okay.
Possible.
Before you start, Mr. Grossman, good morning.
Good morning, Judge. I'm just happy to be here. I'll wait until you finish.
Okay, as long as you're okay, we'll press on. If you, I don't know who's sharing, it's Mr. Colvin. You've learned, hit the red box and you can stop sharing.
Yes, Your Honor. Stop sharing.
Perfect.
Thank you, Your Honor.
You're welcome. When you're ready, Ms. Bader.
Yes, Your Honor. Again, the defendant is legally obligated to pay assessments to the association under the covenants that are actually referenced in the deed to the subject property. If you look at a copy of the defendant's deed, which is Exhibit 1. Also, Mr. Habbassi himself has testified that he has not made a single payment on his account since March of 2020. These defendants are legally required to pay the assessments to the association. And the Georgia Supreme Court has actually, just for sake of making sure this argument is on the record, they have upheld the enforceability of assessments under covenants in the case Timberstone Homeowners Association versus Summerlin. In similar cases, and sorry, the site to that case is 266 Georgia 322. In similar circumstances, there's actually another case, Forest Villas Condominium Association versus Camario, that's 205 Georgia Court of Appeal 617. And I state from that case, I cite, that case says there is no legal justification for a condominium owner to fail to pay valid condominium assessments. Now, I recognize this is a homeowners association and not a condo, but that case and other cases has been extended to apply to homeowners associations as well. And so under Georgia law, the association is entitled to these assessments. They're entitled to court costs, to their reasonable attorney's fees actually incurred. They're entitled to late fees and interest. And they're entitled not just to a money judgment, but in accordance with OCGA 44332, and as stated in all of our pleadings thus far, and in the letter that's been admitted into evidence by the defense, even the March 10th, 2020 letter, that the association, pursuant to the declaration in Georgia law, can pursue foreclosure to recover the judgment amount. The last thing I'll add is, this is not, again, I think there's been some statements made that this matters in reference to Mr. Habbasi's use of his property in some way. And I just want to clarify, this is not what this is about at all. This is simply related to, the association wanting to make sure that things are done equitably. They don't want to compromise or jeopardize the interest of an entire community by excusing an individual owner from contributing his or her fair share. That's the nature of a homeowners association. If you don't pay your assessments, the association can't pay their insurance. They can't pay for maintenance. They can't pay for many of the things, even property management, that they're required to pay to be a properly functioning nonprofit corporation under Georgia law, which is what they are. So this is not personal. This is simply a business trying to obtain what it's lawfully entitled to obtain so that it can do its job properly. And so under the cases that I've cited, Forest Villas, given what the declaration says, given that Mr. Habbasi and Ms. Jabal own their unit in this community and that they've admitted they haven't paid those assessments, the association is entitled to receive those amounts and to obtain them either by money judgment here today, which I'm happy to provide a proposed order to that effect, or to foreclose on the property, which is, I know that sounds extreme, but when you buy a home in this community and you know that that's what the covenants say, you're agreeing to giving the association that right if you don't do what you're legally obligated to do.
So I recall having heard some time ago in this case that Mr. Habbasi was saying, I'm trying to pay, but I'm locked out of the portal. So I bet that someone on your legal team had heard that as well. Were there any steps that your firm took with your client to get the portal unlocked, accessible for Mr. Habbasi?
No, however, there was at our last trial or hearing, and I don't want to get into settlement negotiations, but the reason—
That's already happened.
Okay, the reason we are here is because we'd actually tried to enter into a settlement agreement whereby some of these amounts would be waived, but we never got a signature from the other side. So that's why we didn't file a motion to enforce a settlement agreement, because
there was nothing to enforce.
So, here we don't, again, this is not personal, and I don't think the association wants to be here spending these fees to do this. I mean, we could have had a call before today to try and enter into potentially some kind of agreement. We've offered that, but these amounts are owed, and the association shouldn't be punished for having to pursue legal remedies and an attorney to try to recoup what it's legally owed.
Okay, understood. Mr. Colvin?
Yes, Your Honor. May I stand at the podium?
Wherever you want to be.
Your Honor, again, I would state that under Defendants 1, the 3/10/2020 letter, there are $976 worth of late fees, attorney's fees, and no explanation or justification for those fees has been provided, as none of the witnesses proffered or presented by the plaintiffs addressed that or had any knowledge of it. There's been a lot of effort at avoiding this court's looking at and addressing the 3/1/19 letter. My client, I believe, defending this case had to establish his understanding of what was going on after he had made the payments, even after that letter was sent to him. I'm sorry, the first letter, Defendants 2. I'm a little out of practice, Your Honor, but I'll be honest, that is something that always befuddles me. I get confused up here with exhibit numbers. I'm not confused about what I'm trying to say, but then that messes me up. But Defendants 1 was a letter, a demand, a notice that gave rise to this situation. That is what we have proven. That is unrebutted testimonial and documentary evidence from my client today. We have proven that. There has been no explanation regarding the assessments that were allowed and accepted on the portal from March 1st, 2019 until February 28th, 2020, why those were shown on that letter. My client's unrebutted evidence is that he was being, the 976 was related to that and is absolutely relevant to this court's decision. My client had,
So assume for a minute I agree with you. I don't know that I do, but assume that I do. Isn't the solution then, instead of it being 12,062, it's about 11,062 that is owed, that hasn't been paid. And the best explanation I've heard is I couldn't figure out how to get the portal to work. I mean, how do you get past all the other dollar amounts? You win $1,000 and still lose the house.
because all the dollar amounts related to late fees, related to attorney's fees, are all born of what happened and resulted in the issuance of the March 1st, 2019 letter. And my client's testimony, Your Honor, wasn't, I couldn't figure it out. My client's testimony was, I was blocked and I continued trying to make it. And then he paid me money to try to pay to them. So Ms. Bader has stated in her place that there's been no effort to make that payment. But as I've stated to the court, through his confirming testimony, he gave me $2,000 to try to get this resolved under terms that he could handle and manage, along with picking back up, making his current payments. There was no response to that. And I believe, is this Mr. Donahue in the court? I communicated with Mr. Donahue and they never responded to that, Your Honor. So my client made that effort to make the payments an alternative. My client talked to me about addressing that.
Okay, it also sounds like there was a settlement that you or your client declined to sign. So both sides made some offers, they weren't accepted. I don't get in the middle of that. It really wasn't appropriate to get into it to begin with. I may not have seen Ms. Bader standing up. Next time, yell when you stand up too. But either way, your focus on the $976 is interesting. And I could see why Mr. Habbassi would be frustrated by that. I'm not seeing how it justifies the non-payment of assessments ever since. And it has been a non-payment. And I am not persuaded that pinging the portal once a month, oh, it's still blocked, occasional phone call to that was an effort, but it wasn't a successful effort. And the legal obligation was to make the payment. It's not persuasive that for 2 years, bumping up against the locked portal, it's still locked. I'm going to keep living here and not pay the assessments. I can think of other ways that the assessments could have been paid if there was a sincere desire to get them paid. And they weren't. So here we are. So I don't want you to dwell a whole lot more on that 976, because maybe the solution is, you're right, your client owes 11,000 instead of 12,000.
And again, that's if the
still
court
could be a foreclosure.
If the court is inclined to find that they have met their burden regarding the amount of payments, because they didn't meet their burden regarding anything prior to Mr. Cooper's assumption of the duties. He testified regarding the one page that the court limited. It had hearsay evidence that came from the prior amounts. So they should be limited to what Mr. Cooper testified to, Your Honor. It's not a gimme. They got the burden. They could have put Ms. Fan on. They could have put other witnesses on to address all those, but they trying to get away from the fines. I understand. Maybe I've over-focused on the fines.
I don't know what fines you're talking about, because I haven't seen any fines in any document.
It's referenced in the, I'm sorry, Your Honor.
But he wasn't fined. He said he could be fined, but he wasn't. There are no document in the record has a fine amount that was ever assessed against your client.
It was threatened to be assessed, Your Honor.
Okay.
And then in March 20, the amount came out, not the attorney's fees in exact, because the attorney's fees was a reference back to the March 1st, 2019 letter. But if I could just state this, because I have to perfect the record, Your Honor.
Okay.
I have to done my best at a robust defense. It may not carry the day, but I'm trying to do my job here.
Okay.
And again, I would reiterate and point back to 44.3.223, which again says that they cannot do anything, take any actions that denies the lot owner or occupants access to the lot owned or occupied. And that is impliedly what they've done in violation of this law. They're prohibited from doing it. But my client, they haven't met their burden of proof. My client has explained, maybe to the court's liking or not, but he has explained his position, and we had asked that the court deny the petition in full, not foreclose the lien on the property. Thank you, Your Honor. Appreciate
welcome.
the court's considerations.
I appreciate the effort both sides have put into this case. I will take this under advisement. If there is an order that I would like one of the sides to draft, Ms. Niles will let you know. The other side will have a chance to offer up edits, not to change the ultimate outcome, but to say, I don't think that's what the record showed, et cetera. But I may keep the pen and come up with the final order and judgment or whatever the outcome is. But I'll want to do it soon because I know this has been hanging over Mr. Habbasi's and Ms. Jabal's head for a while with some uncertainty. And I know that Briargate has been trying for a while to be made whole on at a minimum, the unpaid assessments. So I will do what I can to get on that soon. Ms. Bader, anything else on behalf of your client?
I don't believe so, Your Honor. But I do want to make sure that the court has everything they need with respect to the attorney's fees that were incurred in this matter. Is there anything else that the court needs from us with regard to the attorney's fees?
I mean, you've given me what you've given. I don't get to, I mean, I can ask questions and whatnot, but you have set forth what you think is evidence sufficient to tie up each of, it's a 5-element sum: principal owed, late fees, interest, attorney's fees, and court costs.
Correct.
No fines. And that adds up to the amount that you've sought. So I've got what I've got. Mr. Colvin, anything else from your side?
Yes, Your Honor. I wonder if the court would entertain, and maybe Ms. Bader needs to sign off on this, but I would like to move forward regardless, not trying to impact the court's decision whatsoever. But would the court contemplate ordering the plaintiff to allow or confirm that the plaintiff will accept payments under other means if they're not going to unblock the portal?
So
I'm moving forward.
No. I will express some significant amazement that the portal issue, we're done with evidence, so you don't need to explain it, but I would have expected to hear something from Briargate as to why the portal remains closed to Mr. Habbassi. There may be a good reason for that, but there was no reason given. And maybe it's not closed. Maybe he's using the wrong password, but the only evidence is that Mr. Habbassi or his wife or both of them every month have tried to pay, go to the portal, and they get that do not enter sign. I'm not finding that excuses their legal obligation, but it adds a level of complexity that if I were Briargate, I would want to either explain or remove. Hey, the portal is wide open. You need to catch up, but you might as well stay current. And so paying, I'm making the number up, the $1,000 you owe each month, at least starting now, you're not falling further behind. And the only evidence I have is that the portal remained shut to Mr. Habbassi. So I'm not asking anyone to open anything they don't want to open. I would hope that if Mr. Colvin reached out to Ms. Bader to say, we are ready to start pushing some money across the transom, whether it is a check from Mr. Colvin's trust account to Sierra Coulter, Coulter Sierra, whatever it is. I'm not going to get in the middle of that. It does seem like it would behoove one side to start paying the amounts owed to the other side, and see where that goes. So that's something that you could talk about after I leave the bench. That's something you don't have to talk about. I'm not going to require anyone to do any of that. But I would be surprised if my final order in this case says Mr. Habbassi and Ms. Jabal owe zero. So it may behoove the two sides to start talking about how to make, I know you already have, and there was an agreement on dollar amounts, but those disagreements had nothing to do with the portal being locked, because that wouldn't have been money that would have been slid through the portal directly to Briargate. So I encourage you guys to keep talking, and we'll see what comes out first, my order or an email saying, you know what, we don't need an order, or we do need an order, but we would like it for this amount. Everyone agrees that that dollar amount ought to be the size and scope of the judgment. All right.
Thank you, Your Honor. Thank you
You're
very
welcome.
much.
Thank you, Your Honor.
Mr. Habbassi, I think one reason we had to delay this once was that your wife was having a child. Is that correct? How, is that your first child?
Third one
Third child. And how old is that child now?
is a year and a couple weeks.
Doing okay?
He's great. He's
Good.
a happy baby.
That's what he told me yesterday.
That's the best kind to have.
Yes, sir.
All right.
He
Glad to hear it.
smiles. He smiles every second, every.
Maybe he can open the portal. All right.
Thank you, Your Honor. Should we be excused?
You may. But before we go, Ms. Jones, I want to make sure you are taken care of. Do you have the contact information for the lawyers on both sides?
Yes, I do.
Great. If they give you any trouble, let me know.
Thank you.
All right. I'm going to